Welcome back. Tomorrow, Jennifer Crumbley's involuntary manslaughter trial will begin with opening statements, and just this afternoon, the prosecution and defense agreed on 12 jurors and 5 alternatives.
Crumbly and her husband are each charged with 4 counts of involuntary manslaughter after their son shot and killed 4 Oxford High School students in November of 2021. Their son was sentenced to life without parole.
And throughout this jury selection, many questions have dealt with parental responsibility and guns. And new tonight, we're learning more about the jurors. About half of them are gun owners themselves. Others had parents who kept guns in the house, and some jurors were actually excused between yesterday and today, including a woman this afternoon who was adamantly opposed to guns, even with those who use them for hunting.
Joining us tonight to discuss are defense attorney Lillian Diallo and former federal prosecutor Rick Convertino. Thank you both for joining us.
Thank you.
So we covered this beginning yesterday extensively, talking about jury selection, and it was widely assumed this could take a while, maybe a few days at least. Rick, are you surprised at how quickly the jury has been seated?
Very surprised. I would have guessed that this would have taken at least 2 weeks in my experience. When I was contacted today by the executive producer, Ken Beck, I told him that it would be impossible for a jury to be seated today. That's how confident I was and how unusual from my perspective that a jury could have been impaneled this quickly in a case like this.
So what goes through your mind when you're finding out it did happen that quickly? What are you thinking about going forward?
Well, it's so unusual. I've been a trial attorney for 34 years. And I've never seen a jury impaneled in a case like this so quickly. And so I have great doubts that either the prosecution or the defense at this point in time can say with any confidence what their jury is who's making up their jury panel and what they're thinking, where they're leaning. I think it's at this point, it's just a big guess.
Yeah, and there's so many things, Rick, about this case that are unusual. We've been talking about that from the beginning. Lillian, for you, what are your thoughts on them expediting this process and shocking really so many?
So I don't know how expedited it was, only because I don't know what the judge's pretrial orders were, how much was done before. Did they use questionnaires? What did they use to get their jury? I just don't know. And it is a non-capital case, so you only get 5 preemptories. That's the problem for me, right? I've had capital cases. That means murder, homicides, carjackings, right? You get 12 preempts. In a non-capital case, you only get 5. That means 5 people you can just get rid of for no reason.
Those are the alternates, or what does preempt mean?
Preemptory challenge means you can say, okay, that jury right there, they're not a good fit. I'm going to thank and excuse them. So if you use all 5 of those, then you have to work on for cause, like we hate guns, we hate people, things like that. And sometimes the judge will say, well, that's not really a good cause. I had one, he was a Macomb County sheriff, and it was a drug case out of Macomb County. He said, I can be fair. Judge said, well, he said he can be fair.
Well, Lillian, in your experience, isn't it true that in a case like this, under the statute, the judge can actually allow more preemptory strikes? And so that's what I would have expected.
A case being so high profile?
High profile, so gripping to the community, so many witnesses that are, 80 witnesses you have a potential jury pool of 350. And so under the statute, which is Michigan Compiled Law 768, it allows, as Lillian accurately said, is you have 5 preemptory strikes, but upon motion, the judge can allow from 1 to several more. In my experience, in a case like this, that's what would happen, because of the amount of juries and the pretrial publicity that was overwhelming. That you're not going to have a juror who's sitting there that doesn't know about this case or has been made aware in some perspective of the facts as they believe they know them from the media itself.
Yeah, it'd be hard to find anyone who hasn't heard something about this. And I know we still don't have all of the factors in terms of the decision to move this quickly, but do you think that this could be any indicator of the tone of how this proceeding will continue, like pretty fast?
Seems it will be. Seems it will be expedited.
With 80 witnesses? How many witnesses? 80?
Well, they say 80, but you know how that goes too. 80 means 20. And so I wouldn't expect 80 to be called, but that's their witness list was 80 as of today.
Why fast track a trial in general? For who does it benefit to get through this quickly?
The judge, the court. I'm serious. They have dockets, they have schedules, they have the Supreme Court Administrative Office. They're saying, okay, you have this many cases on your docket. They need to move in a certain amount of time.
And they have to do 2 trials with this related
Yeah,
case.
I mean, so if I'm a defense attorney, yeah, you kind of want to be out as quick as you can, but you can't. Right? This is somebody's life. So you have to take your time. You have to go through all the elements. You have to go through the factors. You need to know who's on that jury, because I bet you it may be 1 or 2 sleepers. You never know.
Right.
Because I've had them.
And speaking of the jury, we just heard that a little bit of half of them, almost half of them, are gun owners. Any thoughts on that?
Good. I'm all for gun ownership, but I'm also for responsible gun ownership and legal gun ownership.
Why are the jurors' opinions and beliefs about gun ownership so key to this case and key to them being on the jury?
If you're anti-gun, like the lady said, she doesn't even believe in using them for hunting, right? So if you're anti-gun, your mind is going to be made up. That's an extreme. You don't want extremes from either end, prosecution or defense, sitting on a jury, right? There's nothing she's going to listen to, or
Rick,
he.
is this something that the defense, the attorneys, are likely to celebrate, to be happy about, this belief for many of the jurors?
The anti-gun belief or gun?
Half of them are
owners?
gun owners, or others, their parents own guns. They're a little more familiar. It's not a jury full of anti-gun ownership people.
Well, the thing about gun ownership that's key, or gun use in general in a case like this, or familiarity with guns, is that it's responsible gun ownership, gun use, awareness. And one of the key elements in this case is that Jennifer Crumbley was aware of the potential consequences and ignored them, which would rise to criminal negligence or wanton recklessness. And so gun ownership in and of itself, I don't think is, unless, as Lillian pointed out, you have a juror that says, under no circumstances, am I in favor of gun ownership or guns in general, including, sports, for sportsmanship. And so that's important. But just gun ownership, it comes down, a gun owner, and I'm a gun owner, and I have a CPL, and so I'm fully aware of the responsibility that includes. And so that's the type of juror that you'd want as a prosecutor, that gun ownership and responsible gun ownership and awareness of the potentiality of gun ownership is critical, and therefore this woman, Jennifer Crumbley, discounted and discarded all of that in a negligent and reckless, wanting way, and allowed her son not only to have a gun when he was so incredibly mentally ill, and also she took him to a gun range to train.
Well, as we said, opening arguments will begin tomorrow, and we will be covering this extensively. I'm sure we'll have you both back. Attorneys Lillian Diallo and Rick Convertino, thank you both for joining us.
Thank you.
And we'll be right back.
Thank you.